Judge blocks expedited deportations of those who entered the U.S. legally, possibly curtailing ICE courthouse arrests. Recent federal court rulings have delivered significant blows to aggressive immigration enforcement tactics. A judge has blocked the expedited deportation of migrants who entered the U.S. legally, and an appeals court upheld restrictions on immigration stops in Los Angeles based on language and occupation. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. A federal judge on Friday blocked the Trump administration from rapidly deporting migrants who entered the U.S. legally on humanitarian grounds, potentially curtailing arrests at immigration courts that have triggered controversy across the country. U.S. District Judge Jia Cobb of Washington, D.C., barred federal immigration officials from using two Trump administration directives to apply a fast-track deportation process known as expedited removal on migrants who were granted immigration parole to enter the U.S. at an official port of entry. Parole is an immigration authority that allows federal officials to admit foreigners on humanitarian grounds, and lets them live and work in the U.S. legally on a temporary basis. If left in place, Cobb's ruling could significantly hinder the Trump administration's aggressive efforts to ramp up its mass deportation campaign by targeting migrants allowed into the U.S. under the Biden administration through the parole authority. The Justice Department is expected to appeal her order. One operation in particular that could be curtailed by Cobb's ruling is a Trump administration effort to convince immigration judges to dismiss the court cases of certain migrants, so that immigration and customs enforcement agents can arrest them after their hearings and place them in expedited removal. Unlike immigration court cases, which typically take years to complete due to a backlog of millions of unresolved claims, expedited removal allows officials to more quickly deport migrants who arrived to the U.S. in the past 2 years. Those placed in that process face summary deportation from the U.S. unless they express concerns of being persecuted in their home countries and prove to an asylum officer that their fear is credible. The courthouse arrests have been reported in cities across the U.S., with videos emerging showing ICE officials detaining migrants immediately after their hearings conclude. In some cases, those taken into custody have been seen weeping and visibly distraught. The practice has been strongly decried by Democratic lawmakers and advocates, who say it punishes people who are trying to follow the legal process by showing up to their hearings. In her opinion, Cobb found the Trump administration's efforts to be illegal, saying the lawsuit against the expedited deportations raised a question of fair play. She noted the plaintiffs in the case, two migrants from Cuba and Venezuela, had played by the rules, entered the country with the government's permission and attended their court hearings and were nonetheless targeted for expedited deportation. This case's underlying question, then, asks whether parolees who escaped oppression will have the chance to plead their case within a system of rules, Cobb wrote. Or, alternatively, will they be summarily removed from a country that as they are swept up at checkpoints and outside courtrooms, often by plainclothes officers may look to them more and more like the countries from which they tried to escape. Stephen Yale-Luer, an expert in U.S. immigration law, said Cobb's order could mean that several 100,000 people will be temporarily spared from immediate removal under the expedited removal procedures. Yale-Luer noted the ruling is a reprieve for many of the more than 500,000 Cubans, Haitians, Nicaraguans and Venezuelans who were allowed into the U.S. through the parole authority, under a Biden administration sponsorship policy. It also protects some of the nearly 1 million migrants paroled into the U.S. along the southern border under another Biden-era policy powered by a now discontinued phone app known as CBP One. In a statement, DHS Assistant Secretary for Public Affairs Tricia McLaughlin denounced Friday's order. "This ruling is lawless and won't stand," McLaughlin said. Appeals court keeps in place restrictions on immigration stops in LA based on language and job. The Ninth U.S. Circuit Court of Appeals declined to lift a temporary restraining order that bars immigration agents from using a person's language or job as the sole reason for detentions. An appeals court on Friday kept in place a Los Angeles federal judge's ruling that bars immigration agents from using a person's spoken language or job, like day laborer, as the sole pretext to detain them. The Ninth U.S. Circuit Court of Appeals said in its ruling that there seemed to be one issue with U.S. District Judge Mame Yusi Mensah Frimpong's temporary restraining order, but it did not put it on hold as the government sought. The appeals court said that a part of the July 11 temporary restraining order referring to, except as permitted by law, was too vague. Defendants, however, are not likely to succeed on their remaining arguments, the court ruled, referring to the U.S. government. Frimpong, a judge at the U.S. District Court for the Central District of California in Los Angeles, issued the temporary restraining order after a lawsuit was filed by people who claimed they were detained by immigration officers without good reason. 3 people were waiting at a bus stop for jobs when they were detained by immigration officials, and 2 others are U.S. citizens who claim they were stopped and aggressively questioned despite telling agents they were citizens. Other organizations, including the United Farm Workers, also sued. Frimpong wrote in the temporary restraining order ruling that the people suing were likely to succeed in proving that the federal government is indeed conducting roving patrols without reasonable suspicion and denying access to lawyers. The July 11th restraining order bars the detention of people unless the officer or agent has reasonable suspicion that the person to be stopped is within the United States in violation of U.S. immigration law. It says they may not base that suspicion solely on a person's apparent race or ethnicity, the fact that they're speaking Spanish or English with an accent, their presence at a particular location like a bus stop or a day laborer pickup site, or the type of work one does. Los Angeles has been targeted by the Trump administration for immigration raids that the city's mayor has decried as a campaign to terrorize residents. The lawsuit that led to the temporary restraining order was filed against Homeland Security Secretary Kristi Noem, the head of Immigration and Customs Enforcement and others. Kyle Harvick, the deputy incident commander for the government's immigration action in Los Angeles, said that certain types of businesses, including car washes, were chosen by immigration agents because past experiences have demonstrated that illegal aliens utilize and seek work at these locations, according to the appeals court ruling. The appeals court found that the 4 enumerated factors at issue, apparent race or ethnicity, speaking Spanish or speaking English with an accent, particular location, and type of work, even when considered together, describe only a broad profile and do not demonstrate reasonable suspicion for any particular stop. The appeals court panel said that the government did not dispute constitutional issues when trying to get the temporary restraining order stayed. They did not meaningfully dispute the district court's conclusion that sole reliance on the 4 enumerated factors, alone or in combination, does not satisfy the constitutional requirement of reasonable suspicion, the appeals court panel wrote. Mark Rosenbaum, senior special counsel for strategic litigation at Public Counsel, which is among the groups representing the people who sued, said Friday that the actions by immigration agents in the Los Angeles operation were unconstitutional. Today's ruling sends a powerful message: the government cannot excuse illegal conduct by relying on racial profiling as a tool of immigration enforcement, Rosenbaum said. These raids were unconstitutional, unsupported by evidence, and rooted in fear and harmful stereotypes, not public safety. The appeals court did find that part of Frimpong's temporary order was vague, relating to, except as permitted by law, in the clause about detaining people based on the 4 factors of race, speaking Spanish, a location or type of work. But it otherwise denied the government's motion for a stay. Los Angeles Mayor Karen Bass, a Democrat, called the appeals court ruling a victory. "Today is a victory for the rule of law and for the city of Los Angeles," she said in a statement. The temporary restraining order that has been protecting our communities from immigration agents using racial profiling and other illegal tactics when conducting their cruel and aggressive enforcement raids and sweeps will remain in place for now. The immigration raids launched in Los Angeles in June resulted in large protests in the city, some of which turned violent. The Trump administration sent National Guard troops and Marines to Los Angeles in a move that was condemned by Bass, California Governor Gavin Newsom and others. DHS Assistant Secretary Tricia McLaughlin rejected claims that immigration enforcement is based on race or ethnicity, saying agents are targeting individuals who are in the country without legal authorization. She also accused unelected judges of undermining the will of the American people. This video highlights growing judicial resistance to enforcement strategies viewed as discriminatory or unconstitutional. As legal battles continue, the future of immigration policy and deportation practices remains under intense national scrutiny. That is all for today, in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later, in the next video. Till then, take care.
Just laws expedited deportation of those who enter the US legally, possibly curtailing ICE courthouse arrest. 2 major federal court rulings have recently restricted immigration enforcement tactics under Trump-era policies. In Washington, D.C., Judge Jacob blocked the expedited deportation of migrants who legally enter the U.S. on humanitarian parole, protecting hundreds of thousands from sudden removal. A ruling halts ICE operations that targeted migrants at the court hearings, calling the practice unfair and a violation of due process. This video shows many Cubans, Haitians, Nicaraguans, and Venezuelans parole under Biden policies. Meanwhile, in Los Angeles, the Ninth Circuit Court of Appeals upheld a temporary restraining order preventing ICE from using a personal language authenticity or type of work like a big a day labor as a sole result for detainment. This video followed a lawsuit after aggressive immigration sweeps in the city. The court found the raids likely unconstitutional, rejecting racial profiling as a legal basis for enforcement. Los Angeles Mayor Karen Bass praised the ruling, while DHS officials criticized it as undermining immigration authority. Both decisions mark significant checks on harsh enforcement methods.